Good afternoon, everyone, and welcome to another live edition of Employment Law Q&A and Disability Insurance Law Q&A. My name is Alex Lucifero. As you can see, I'm an employment lawyer and disability insurance lawyer with Samfiru Tumarkin, LLP. I also manage the firm's Ottawa office, coming to you live this afternoon from a quite sunny, quite nice Ottawa, Ontario. Welcome, everybody. As our regular viewers will know, this is a live stream that we do pretty much every day of the work week, and we are here to answer any and all questions related to your employment. This is what we're here to do. We're here to help resolve your workplace problems. If you are currently struggling with any kind of employment issue, any issue at work, if you're dealing with a difficult boss, or if you feel like your boss is bullying you, if you've been let go from your job, certainly, if your terms of employment are changing in any particular way, your employer is asking you to accept a change in circumstance, this is your opportunity to get your questions asked. This is your opportunity to speak with directly live right now with an employment lawyer. I don't know about any other areas of law. Don't ask me a family law question. Ask me any and all employment law questions you want as well. And we have Tracy coming through as well with the first question of the day. I see you, Tracy. If you have any disability insurance questions or long-term disability insurance or even short-term disability insurance questions, go ahead and ask those as well. They're, of course, related to your employment. They're related to your work. These are group benefits plans when we're talking about disability insurance. And so please, by all means, go ahead and ask those questions. Again, we're live right now tackling any issues under the employment law sun. Before I get into a couple of topics and the questions that, of course, I wanted to deal with today, a couple of pieces of contact information. If you're perhaps too shy, too bashful to ask your question online, you certainly shouldn't be. But if you are, here is where you can find us. First and foremost, our website, www.employmentlawyer.ca. Employmentlawyer.ca is where you can find us. We have a ton of resources, a ton of information on our website. If you are looking for some information on constructive dismissals, or if you are looking on the latest issues in the news that come up with respect to employment law, go ahead and visit our website. We've got a ton of articles, a ton of news articles, blog posts, videos, any kind of resource that you can think of to get you pointed in the right direction. You also, of course, have our contact information on our website. If you're looking for a particular lawyer in a particular area, go ahead and visit our website. We've got all of our various offices listed there, all of our lawyers listed there with all of our contact information as well. If you want to email us directly with respect to your employment law issue, help@employmentlawyer.ca is the email address you should forge into your memory. help@employmentlawyer.ca. Send us a brief email with respect to your situation. Give us a brief description. I promise, guys, someone will get back to you if you email us at that email address. We help hundreds and hundreds, if not thousands of people across our various offices every single day. People who simply email us in with a question. Again, email us at help@employmentlawyer.ca as well. I will list our phone number as well if anybody wants to give us a call and reach us by telephone. I don't know it by heart, but it's there on the screen for you to give us a call at. Feel free to call in, leave a message. If no one picks up the phone, we have a whole team of people that take calls, take emails, and get back to people as quickly as we can to help. Again, point them in the right direction, get them the legal information and the legal advice that they need to hopefully resolve their workplace problems. With that introduction out of the way, and I did want to speak about a couple of issues that have come across my desk this week in the employment law world, but questions always take priority, and there are already a good number of questions here, so I will get to them. Quick point before I get to Tracy, who is first in line today. For those of you watching right now, please go ahead and ask your questions. No confidential information needs to be shared. You could be very discreet about what you're asking for. Ask it in a very general way. I promise you, not only will we help point you in the right direction, by asking your question, you're going to be helping probably dozens, if not hundreds of other people who are viewing this either right now or at some point in the future, because all of these are on our YouTube page. Someone will be in the exact same situation as you. Someone will have the exact same problem as you. You will be helping not only yourself by asking your question, you will also be helping dozens of other people out there that are dealing with exactly the same type of situation. Again, anything under the employment law sign. If you have a very technical pension plan question, go ahead and ask it. I will do my best to respond, and we fielded every single question under the sun when it comes to employment law. Again, don't be shy, everyone. Please go ahead and ask your questions, and I will get to them over the next 25 minutes or so. Okay, Tracy, as promised, first in line, asks quite a good question. Tracy asks, coming up on 2 years of LTD, meaning long-term disability leave, I've missed 2 raises at work, plus cost of living increases, or cost of living has increased greatly. You're right, it absolutely has, Tracy. Am I entitled to raises in my LTD monthly pay? Tracy, what an excellent question. The answer to your question does not have to do with whether your employer has instituted raises in your actual workplace. Unfortunately, that's not how it works. You're not entitled to those raises, unfortunately, because you are not actively at work. However, at least not at the moment, perhaps when you go back, if you do go back. However, you may very well be entitled to an increase in your LTD, but it depends on the terms of your insurance policy. And so the answer to your question will be in the disability insurance policy that your insurer and that your employer has. These are oftentimes called cost of living adjustments, or COLA, or COLA for short. Lots of insurance policies will have cost of living adjustment increases such that the monthly benefit increases every year based on a cost of living calculation. Tracy, have a look at your policy. If there is a cost of living increase incorporated into the policy, you're absolutely owed increases in your monthly benefit. If not, unfortunately, you are not. It's going to be the same amount year after year or month after month, because there is no cost of living increase in the policy. The general answer to your question, as you can probably tell, is it depends on your insurance contract with the company. It is the insurance policy, which is a contract, that prevails here. Whether you knew the exact terms or not when you signed up for your group insurance plan, whether you agree with those provisions or not, the insurance contract applies. Those are the rules of the game that both the insurance company has to follow and you have to follow as well. If that contract includes cost of living increases, you're entitled to them, no questions asked. If cost of living increases are not part of the insurance policy or not part of the insurance contract, then you are not entitled to them. And unfortunately, your monthly benefit will stay as is for as long as you're unable to work. Tracy, if you have any difficulties with the insurance company, if you have any problems either getting disability benefits or continuing your benefits, or if you have any problems returning back to work for that matter, your employer perhaps is giving you a hard time, don't be shy to reach out to us. We deal with these situations pretty much every single day, representing individuals, employees, both against insurance companies and also against their employers when they're not been given a fair shake. Thanks for your question, Tracy. It's a great one to start the afternoon off with. Julie is next in line. No question, but Julie, thank you so much. She says, you guys are amazing. Thank you. Thank you so much for the support and for watching. Julie, much appreciated. Rocket asks, if you work for one of the gig working apps like Uber Eats and Skip the Dishes or DoorDash, they call you independent contractors, but what does the law say about this very debated topic? Rocket, excellent question. You may know this yourself, perhaps not, however. We actually represent the workers of Uber in a class action lawsuit against the company, where our position is, and this is going through the court system right now as a class action lawsuit, where our position is that, as you say, Rocket, Uber employees, whether it's Uber Eats or Uber in general, are indeed employees of these companies and not independent contractors. There are various factors that a court or the Ministry of Labor, for that matter, or even the Canada Revenue Agency in Canada will take into consideration when assessing whether a worker is an employee or is in fact an independent contractor. We can probably all think of pretty good examples of what an independent contractor should be. Someone who works for multiple clients, who effectively has their own business working for multiple clients at any given time, using their own tools, using their own equipment in general, that has flexible hours of work, can decide what the terms of employment are and what the terms of employment or terms of work aren't. A lot of these factors, Uber employees and DoorDash employees and Skip the Dishes employees do not have. The terms of employment, the terms of work are set by the company, are set by Uber, or set by Skip the Dishes. These are the terms of employment that you absolutely have to follow. Even though some of it might be using your own equipment, that speaks to an employment relationship. At least, again, that is what our position is. Rocket, you might know this again yourself already. In lots of other jurisdictions across the world, I could think of the UK, I could think of California, I believe even New York. All of these other jurisdictions have found that these workers are employees and not independent contractors. I suspect the province of Ontario, and I can only speak for the province of Ontario alone, because I am only licensed to practice law in Ontario. I suspect that that is likely where Ontario is going to go as well, that these employees will ultimately be considered exactly that, employees rather than independent contractors. You're absolutely right, Rocket. It's a very interesting debate. And ultimately, I think the result will be in favor of workers rather than these companies. I believe these workers are indeed employees of the company. Thanks for your question. You're right. Very interesting one. Speeches Beyond asks, 6 years at the company, bullied by a co-worker in management. Sorry to hear that. Finally wrote an email to my boss, and suddenly I'm being blamed for the same reason, for the same thing, and was fired. I have 5 prior coworkers who saw me being bullied. Speeches Beyond, I'm sorry to hear about that. First and foremost, it should be noted, and this should be general knowledge, but in case it isn't, employees in Ontario and throughout Canada as well have the right to work in an environment that is free from bullying and harassment. That's not because I say that that's the case. That is written into our laws. In Ontario, that is written into the Occupational Health and Safety Act that provides minimum protections for employees with respect to health and safety. Being safe from bullying and harassment in the workplace is one of those protections that an employer has to provide by law. There's no question about it. If an employer, if it's brought to the attention of an employer that an employee is harassing another employee in the workplace, that employer has, again, a legal obligation by law in black and white. It says that that employer has to investigate the incident and take steps to remedy the situation. Speeches Beyond, of course, remedying the situation doesn't mean firing the employee who voiced their concerns in the first place. That's obviously a problem, and that's problem number 1 in your case, which is that if you were let go because you filed or because you voiced your concerns to your boss about the way in which you were being treated, that is what we call a reprisal at law. It is illegal. An employer can be punished, can receive damages or penalties rather as a result of that treatment. Again, that is problem number 1 with your situation. If you were let go because you voiced your concerns, that is illegal in and of itself. Issue number 2, Speeches Beyond, as a 6-year employee of the company, you are going to be owed severance, and your severance entitlements will likely be significant. Severance is based on an employee's years of service with the company. So in your case, Speeches Beyond, we have 6 years, their position within that company, and their age. So depending, Speeches Beyond, on how old you are, and depending on your position within that company, for example, if you were in management, as maybe you were alluding to there, listen, your severance entitlements might be in the range of about 8 to 10 months, not weeks, months of pay if you were in Ontario or even potentially another province in Canada. So your severance entitlements might be very, very significant. We're obviously talking about tens and tens, if not potentially hundreds of thousands of dollars here. And again, that's the second issue. You have the first issue to contend with, which is we can also pursue the company for the way in which you were treated, which again sounds like it may very well have been a reprisal. Speeches Beyond, if you feel comfortable enough telling me how old you are and your position within the company, I can give you a better sense of what your actual severance entitlements are. Post another time. I'll keep an eye out for it. and I'll circle back around and tell you what I think your severance is based on 6 years of service. Again, I need your age and your position in the workplace. All right, JC 2004 asks, in the event a third party requires you to get a COVID test to enter a work site, what rights do you have to ensure that the test and the test results are not retained or shared by the third party? This is a second post now. The company does the testing, not your primary employer. I don't know if any information was saved. They gave a colored wristband to enter the site. JC, you would want them, so this is now the third party, the company, you would want them to confirm that the information that they've received, the negative test, I guess, has indeed been destroyed. Or alternatively, what you want to do, if they're doing rapid tests, for example, take back the actual physical rapid test. Take it with you. Ask for it at the end of the day or whenever, once it's confirmed negative, so that you can destroy it yourself or keep it yourself. That's the way I would do it, or watch them dispose of it. One way or the other, as long as it gets tossed out, that should do it. Don't be overly paranoid about the situation would be my advice, but you certainly have a right to ask that for them to confirm the information is not kept or stored anywhere, and then ultimately any kind of tests that are done are destroyed or disposed of. I love the questions, guys. Keep them coming. We have about 13 minutes left on the show. For those of you just tuning in over the past couple of minutes, my name is Alex Lucifero. I am an employment lawyer, a partner with the firm Samfiru, Tumarkin, LLP. We are talking any and everything employment law today, and disability insurance law as well. Let's not forget. Happy to answer any questions about short-term or long-term disability benefits if you're dealing with those issues. Also happy to answer any questions related to the workplace. If you're having any kind of difficulties at work, whatever the issue is, maybe it's an employment contract you're dealing with, maybe you've been temporarily laid off your employment, maybe if you have health and safety concerns about COVID protocols in the workplace, go ahead and ask right now. We've got about 12 minutes left to get those questions answered, and I'm more than happy to. Hopefully I've already helped a few of the individuals that have already asked questions today. We've had some really, really good ones. All right, next in line is Julia. Julia, thank you for your question. She asks, my employer has announced that the commission rates are going to change for the next quarter for all sales rep and are decreasing by half. Can they do this? It will really impact, I just lost it there for a sec, Julia, it will really impact my annual income. Great question, Julia, very topical question. I'm not sure what's going on in workplaces nowadays. I have seen this a ton over the past year. I think it is related to employers tightening their belts and trying to cut costs. And unfortunately, it is salespeople that take a hit here when commissions get reduced or salaries get reduced, bonuses get reduced. I've seen it, again, lots and lots and lots, Julia, so you're not the only one. If your commissions are decreasing by half, Julia, and that is going to have a big impact on your total income, they are not allowed to do this. This is what we call a constructive dismissal. A constructive dismissal is whenever an employer changes the terms of your employment in a significant way. This could be, again, an employer instituting a temporary layoff. If you've never been temporarily laid off before, sending you home without pay is obviously a big change to the terms of your employment. Employer doesn't get the right to do that. If your employer is changing your pay, as is the case with respect to Julia, yes, that can potentially be a really significant change and therefore a constructive dismissal. Julia, it would be good to know the percentage by which your total compensation is likely going to be changing. This is not a hard and fast rule, but generally speaking, a change that is over about 8% of your total compensation or 10% of your total compensation is going to be considered a constructive dismissal. So if you are making $100,000 in total income, that's both base salary and commissions, and now this next quarter with this change to the commission structure, it might change to maybe making $80,000 a year total. There, let's say you're losing half of your commissions that way. Well, then that would very clear, that's a 20% change, obviously. That would clearly be a constructive dismissal. You have a right to say no in a situation like that, Julia. You can actually, if they insist on the change, you can actually leave, consider yourself terminated, leave your employment, and get a proper severance package based on the full compensation package, not the new reduced one. Julia, before you speak to anybody within the company, before you say yes or no or maybe, you need to speak with an employment lawyer immediately, as soon as possible. Give us a call, send us an email. Again, the email address is help@employmentlawyer.ca. Explain in your email what you just explained to me, which is that your pay is changing in a significant way. They're reducing your commissions by half. I promise someone will get back to you. You absolutely need advice in the circumstances. And don't wait, Julia, because if you wait, that delay might be considered an implicit acceptance of the change. You don't want that to happen. You want to, if you're going to object to the change, you need to do so pretty quickly. Make sure you get legal advice first. We will be able to properly advise you on what you should and shouldn't be saying in your situation. Really important question. Thank you for that, Julia. Lots of people, I'm sure, are dealing with changes to their pay structure, changes to bonuses, changes to commission structures. And if the change is significant, again, if it's over about 10%, give or take, it's going to be considered a constructive dismissal. That gives an employee a tremendous amount of bargaining power to either get that change taken away, for the company to actually back down from their change, or get you a severance package and get you moving on to a new job that's actually going to pay you properly. All right, guys. Rick is next in line. Rick asked, does an employer have to pay out severance if they let you go before seeing the end of a 15-month working termination? Thank you. Yes, Rick. And by a 15-month working termination, I imagine you mean that you've been given 15 months notice of your termination. Rick, if your employer lets you go before that, absolutely you are owed severance beyond that point. It will depend, how much severance you are owed will depend on how much notice you've already received. For example, at least potentially, you might even be owed the balance of that 15-month notice period. Right? If they let you go at month number 7, but you had received initially a 15-month working notice period, you might be owed those extra 8 months. Rick, if that's happened to you, you need to speak with an employment lawyer right away. It's obviously very simple. Again, send us an email, give us a call, be in touch. I'd be happy to chat with you myself if you want to get into the nitty-gritty. You need advice, obviously, in a situation like that. And chances are, yes, absolutely, you are owed more severance if you were let go during that period of time. It would be different if you resigned during a working notice period. So if you were the one that made the decision to leave before your actual end date, that's a different kettle of fish. But if you've been let go during a working notice period, you're still owed severance as an employee. Just circling back to Speeches Beyond. Speeches Beyond, you're 44 and you were in the warehouse, longest standing employee, also fired 3 days returning from a hernia surgery. That's another issue in and of itself, Speeches Beyond. But if you're 44 years of age and you were working in the warehouse and you were a 6-year employee, you're probably looking at 6 months as a severance package, particularly if you're returning to work after a surgery. That would justify a longer severance period. And that might actually also be discrimination on the basis of disability or on the basis of your medical leave. Again, Speeches Beyond, give us a call. You need to have a chat with an employment lawyer. You are owed severance and potentially then some for the way in which you've been treated. Back into the queue, Helen asks, and we're running up on about 5 minutes left, guys, so we'll do it somewhat rapid fire at this point. Helen asks, as a professional engineer in the provincial public sector, can I sue for wrongful dismissal through a labor tribunal? Does it have time limitations for a lawsuit? Helen, if you were in the public sector, I imagine you were a unionized employee, although as a professional engineer, it may have been an association that's kind of akin to a union. If you were unionized, then you are bound by the terms of your collective agreement and bound by what your union is prepared to do for you. And so you should speak to your union about whether a grievance is possible. You should speak to your union about any time limitations. If you are non-unionized, Helen, you have 2 years from the date of your termination to pursue a wrongful dismissal. You should not pursue a wrongful dismissal through a labor tribunal if you are a non-unionized employee. For non-unionized employees, the Ministry of Labor is actually oftentimes, almost always, I would say, the wrong place to go. Again, if you're non-unionized, Helen, speak to an employment lawyer. We can get you pointed in the right direction and probably help assist you through that course. If you are unionized, you need to speak to your union. Unfortunately, you cannot sue for wrongful dismissal. You should be bound by the collective agreement and what your union ultimately decides. All right, Randolph asks, my brother works in a specialized industry that is very reliant on getting new contracts for work. What obligations does a workplace like this have for providing consistent working hours? Interesting question, Randolph. This again speaks to the issue potentially of constructive dismissal, in that if your employer, or if your brother's employer is not providing him with adequate amounts of work, and perhaps that is affecting his income or affecting simply his job responsibilities and the role that he plays in his employment. And if that is clearly the obligation, clearly the duty of the employer to provide, right? If they're just not filling their end of the bargain and it is causing damage to your brother, either financially or just, in the workplace in general, that may be considered a constructive dismissal. The opposite example of a situation like that is when an employee gets overburdened with work and is doing the work of two employees without any additional recognition or compensation. That can also be a constructive dismissal, right? So being given too much of a workload can be a breach of contract. Not being given enough work can also be. Now, those have to be kind of extreme examples, right? If your brother, for example, has to find the majority of the work himself, may not be a constructive dismissal. That ultimately might rest on his shoulders as his responsibility, his job duties. But again, if it's the employer's responsibility and they are not holding up their end of the bargain, then he can potentially have some recourse in that situation. The recourse may very well be to consider the employment contract breached because the employer did not fulfill its end of the bargain. Again, before your brother, Randolph, takes any issue with your employer or discusses constructive dismissal with them, I would certainly say let's have a conversation off air, get into the details. Again, we will be able to point your brother in the right direction, advise him on what his options are, what the menu is, so to speak, and then what his best option would be moving forward to try and resolve the situation. We will leave it there for today, everyone. Thank you so much for joining me on Friday, and thank you very much for all of your questions, those who asked. We will be back at it on our regular schedule next week, and we will catch you then. Until then, enjoy your weekends, enjoy the time off, have a great work week next week, and we will catch you here next time. Until then, take care, everyone. Bye-bye.